Hello, everyone. I have another Supreme Court case that has been issued, and this one is controversial. This order has to do with the Supreme Court lifting a stay order that will now allow ICE to continue conducting roving ICE raids. Let me share my screen. This article is coming out of Politico. And on the screen, the headline reads Supreme Court lifts restrictions on roving ICE raids in Los Angeles. Now, a little bit of background. Back in July, a federal district court judge issued an order that blocked or prevented ICE from conducting these roving raids. Well, the Supreme Court has reversed action on that and lifted the order issued by the trial court. We're not going to read the entire article, just a few headlines. And so here, it says the Supreme Court has lifted restrictions that barred the Trump administration from carrying out immigration related raids in the Los Angeles area based on broad criteria such as speaking Spanish or gathering at locations day laborers often congregate. A little bit further down, the article says the justices who apparently divided in 6-3 along ideological lines put on hold a federal district judge's order that reined in what critics called roving raids by ICE. The judge had found that the tactics were likely unconstitutional because agents were detaining people without probable cause at car washes, bus stops, Home Depot parking lots based on stereotypes. Now, a little bit further down, it says the High Court's majority, it offered no explanation, guys, for its decision to grant the Trump administration's emergency appeal to block the district court's order. However, Justice Kavanaugh wrote separately in support of the decision, saying that it was reasonable to briefly question people who meet multiple common sense criteria for possible illegal presence, including employment and day labor or construction and limited English proficiency. The court's three liberal justices dissented, and they are quoted as saying, we should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job, Justice Sotomayor wrote, joined by Justice Kagan and Justice Jackson. Rather than stand idly by while our constitutional freedoms are lost, I dissent. And that's her quote. Now, this article goes further down to say that the Justice Department complained in an emergency appeal. And guys, we've been seeing a lot of these decisions where the Supreme Court is lifting a prior court's order. We've been seeing this happen through the vehicle of emergency application taken by the Supreme Court. But let's continue to read. The Justice Department complained in an emergency appeal last month that the court ordered limitations amounted to a straitjacket for law enforcement officers carrying out President Donald Trump's mass deportation policy. However, immigrant rights and civil liberties advocates accuse federal officers of stopping Latinos solely because they were speaking Spanish or present at home improvement store parking lots or car washes. With nearly half the population in LA of Hispanic origin, such a broad approach is certain to sweep up many U.S. citizens and legal immigrants, the advocate said. Now, a little bit further down, Justice Sotomayor is further quoted as saying in her dissent that the Supreme Court precedent makes clear that immigration officers cannot rely on ethnicity alone to make stops seeking potentially undocumented immigrants, and ethnicity and language are often intertwined. So relying on only those two factors is no different than relying on ethnicity alone. She said adding certain types of businesses to the mix was plainly insufficient to make the stops legal. Uh, Sotomayor is quoted as saying the High Court's ruling posed a threat not just to undocumented foreigners, but to Americans of Hispanic descent. Now, a little bit further down, the government and now the concurrence has all but declared that all Latinos, U.S. citizen or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to agents' satisfaction, she wrote. Now, the California Attorney General Rob Bonta called the High Court's action today disappointing. He also said the Supreme Court's acceptance of the use of race as a factor in immigration enforcement was in tension with the court's decision 2 years ago ruling out the use of race to prompt diversity in college admissions. How they prevent the use of race to tackle discrimination, but allow the use of race to potentially discriminate is troubling and is disturbing, said Bonta. Now, the Trump administration is hailing the Supreme Court's ruling lifting the court imposed limits that ICE faced in LA and several nearby counties. So, this is a victory for the Trump administration because this ruling will allow ICE raids to continue with what the advocates were describing as broad, sweeping criteria for detaining and arresting individuals. Now, as I said, this was an emergency application to the Supreme Court. The underlying case is still being litigated. It is likely that it could make its way back up to the Supreme Court, where the underlying substance of the lawsuit is argued or further argued, where a decision on the merits could be entered. But what critics who oppose the roving ICE raids are basically saying is that this is nothing more than a form of racial profiling in the context of immigration, seeing if someone is in the U who's an immigrant who's in the U.S. Without lawful status based on things like speaking Spanish or being at a Home Depot or a Lowe's or a day laborer or a car wash or other places where immigrants are known to congregate. And so that's what the most, critical part of the Supreme Court's decision invokes from advocates who oppose this. Now, in a larger context, this lift, as I said, it lifts the trial court order that imposed this. Again, the case is still in litigation. However, it's fair game that what's happening in LA could easily and very well likely be seen in other cities. I've shared with you guys that I am in Florida. South Florida has a huge population of immigrants of all types, and many of which speak Spanish and other languages. And so this lifting of this order certainly has implications for immigrants in every state in these United States. And so, guys, what people are starting to believe, we are ushering into an era where the potential increased racial profiling and a papers, like, let me see your papers, we're ushering back into that era. And as we all know, here in Florida, Florida's SB 4C lawsuit is being litigated. And the essence of that lawsuit is that the law that Florida passed some months ago, if you enter the United States illegally and then enter the US, enter Florida, excuse me, then that is a crime. That case is being litigated. And I believe I shared with you guys some time ago, a Hispanic individual driving from Georgia into the state of Florida, he was arrested under that law, albeit he had an accent, but he was actually a born U.S. citizen. He was arrested. The criminal judge did dismiss the underlying charges against him, but he was detained well over 24 hours, I think up to 48 hours before the ICE hold was actually released or removed, and then he was released. So the Supreme Court's decision definitely has reason for many individuals to have concerns if you are an individual who, quote unquote, looks like someone who could be here illegally or unlawfully, whatever that may happen to look like. Guys, thank you so much for watching. Please share the video. Please be aware, and I will definitely see you in the next one. Bye-bye.